Hello friends, in this video we will have a discussion regarding the applicability of GST on various compensation which is received for non-fulfillment of some contracts or cancellation charges, late payment charges, notice pay recovery from the employees, all these aspects. For this we need to understand the basic concept or the underlying principle which causes this taxability. Thereafter, what is applicable to tax is something that we will understand thereafter, right? Agreeing to the obligation to refrain from an act, tolerate an act, or to do an act. That means I am agreeing to a particular obligation under any contract. Let's say in case of a non-compete agreement, I agree not to compete with my business partner upon leaving the business, right? Or I agree to tolerate the late payment of any person. All these are agreeing to the obligation to tolerate or refrain from an act. So what is covered within this clause? First of all, it has to be number one under a contractual relationship. So the obligation has to be under a contract. The contract may have an obligation either to do something or not to do something. Both are promises in a contract, right? And there should be a clear consideration for doing this. If there is a consideration, then only there is a contract. Consideration must flow from the other party to the contract. So if I'm agreeing with you, the consideration should ideally be flowing from you to me. Next, it should be an independent arrangement in its own right. That means this toleration of an act is itself a supply. It is itself against a facility of tolerating or refraining from an act. It should not be merely a event in a contract. There should be a clear intent of having this kind of arrangement. It may be part of a contract or it may be an independent contract, does not matter. But there has to be a clear existence of this arrangement as per the contract between the two persons. A person under an obligation to do refrain from an act and he does it performs those acts under that obligation, in that case this particular clause would be applicable. Let us see liquidated damages and understand from this perspective. There are three kinds of agreements that we are covering here: liquidated damages, notice pay, check dishonor charges, all of them. The common element is that all of them are recovered for not tolerating an act. Ideally, liquidated damages is basically any compensation which I am receiving for the breach of the contract. I have agreed into a contract that you need to supply the goods within 2 months to me. If you don't supply the contract within 2 months, there would be a penalty of this amount. Right? This is the compensation for breaching of the clause, right? And this amount is recovered because I'm not tolerating that act of yours that you have not supplied the goods to me within 2 months. So basically this is not agreeing to the obligation to tolerate an act, but this is rather for not tolerating the act. And to make sure that this kind of aspect, if it is there in the contract, the activity which I want to avoid is deterred by you. For example, I want those goods within 2 months. If you're not supplying it, in that case there would be a loss to me. So I want to deter you from doing it. I want that you should not be doing it. That's why this damages have been kept, right? The idea is not to have that damage. The idea is for not having that breach. The contract is for execution, right? So until unless there is an independent arrangement that in the contract there is an independent arrangement that since you have not supplied the goods to me for 2 months, there is a new contract which I enter. There is an independent arrangement that you have to pay me this much. That becomes a supply. Here this is merely an event in the contract. The main contract is that the goods should be supplied. Only because it is not supplied within this time period, this liquidated damages occurs. So it is merely a part or an event in the contract. This is not the objective why the contract was entered. Objective was to supply the goods. Only to make sure that the goods are supplied within this period, this arrangement has been entered, right? So if let's say you don't supply the goods, whatever money that you are paying me for the breach in the contract is nothing but mere flow of consideration or mere flow of money. It is not consideration, rather. This is mere flow of money. There is no consideration involved, right? So what we have to understand, that if there is any consideration, there is any quid pro quo, that means what you are paying me is against any activity which I am performing. Here the breach in the contract is not in the activity. Here breach in the contract is merely an event. It is not the object of this particular contract. That's why all these cases, notice pay recovery, employee is coming to me, he is saying that I will serve notice period of 2 months. He leaves within 15 days. So I recover the amount of notice pay money from him. That is again not the objective of the contract. Objective is to deter him from leaving before 2 months. So this is merely an event in the contract, right? And the idea is not to have this breach, but to make sure that the such breach is deterred. So this is again for not tolerating the act. Check dishonor charges. Again, the idea is not to have the check dishonored. Main supply may be something else. Merely because check is dishonored, I am taking some charges which is for not tolerating the act of dishonor. So this is again only an event in the contract. Does not constitute any consideration. So in all these kind of cases, let's say I am in case of an agreement to sell, the earnest money is forfeited. Deposit what you have paid me is forfeited because you don't suffice any clause in the contract. All these are not for tolerating the act. This is for making sure that there is no breach, right? Idea is there is a main contract for which the execution is important. For all these cases, GST would not be applicable. Now, where would GST be applicable? Where there is a facility being provided. For example, I allow you to make a early payment to me, but if you make an early payment to me, in that case you have to pay some charges. For example, bank deducts prepayment charges for loan repayment. Or if you make a late payment to me, you have to pay a certain amount extra. That is late payment charges, right? Or early termination of contract. Normally the contract is for 3 years. If you terminate it within 2 years, you have to pay a certain amount. That is again a facility which is given to you that you can terminate the contract early, right? Or forfeiture of money for travel, hotel, cancellation charges. If you, let's say, don't travel in the flight, in that case the flight takes a cancellation charges of 3,000 rupees. That is again a facility given to you for cancellation. So wherever it is, the idea is that there is a facility being provided to you, or any hotel is providing a facility to cancel by paying these many charges. That is a facility. That is not basically a contract for breach. There is no breach. This is a facility. Pay early, cancel early, terminate early. All these are facilitations. In those cases, the main supply would be the one that we need to look at. Whatever the rate of tax is there on the main supply, let's say 18%, the same rate of tax would be applicable on the facility also. Prepayment charges, late payment charges, same rate of GST would be applicable. And it is immaterial whether we call it in the form of penalty or we call it in the form of fine. It doesn't really matter. In all these cases, GST would be applicable. So in these cases, GST would be applicable. Mind you, here the contract was for breach. Here the GST was not applicable. Here the contract is for providing a facility. That's why GST is applicable. So we need to identify this distinction very clearly. What is the object and the event in the contract? If it is merely an event in the contract, GST is not applicable. If there is a clear objective of providing that particular supply and there is a consideration clearly for it, then GST is applicable. So we have to have this distinction very clear, right? With this, we come to the end of this video. Thank you so much for giving me a very patient hearing.